This week, the Ninth Circuit gave us an opinion answering a question that the U.S. Supreme Court pointedly left open a couple of years ago in its Ritzen opinion. Ritzen, along with the previous Supreme Court decision in Bullard versus Blue Hill Bank, tells us what is or is not a final order in the bankruptcy context. In Ritzen, the Supreme Court said that the denial of a lift-stay motion by the bankruptcy court is essentially always appealable. In a footnote, the Supreme Court said that the justices were not deciding whether an order denying lift-stay but made without prejudice could sometimes be final and appealable. Well, in this decision this week from the Ninth Circuit, the panel unanimously told us in a published opinion that yes, in fact, if the circumstances are right, denial of lift stay without prejudice can nonetheless be a final, appealable order. Here's what happened. The creditor and the debtor had been embroiled in litigation for 7 years in state court on charges of fraud and misrepresentation. Literally on the eve of trial, you know what the debtor does? The debtor defendant files a Chapter 7 petition in California, stopping the state court dead in its tracks. The creditor files a $2 million claim, alleges in a complaint that the debt is non-dischargeable, and also asks the bankruptcy court to modify the automatic stay to allow the trial to be completed in state court, thus answering all of the questions that the creditor was also raising in bankruptcy court. But the bankruptcy judge denied the motion. The district court, on an attempted appeal, in essence, dismisses the appeal, saying that it's interlocutory and I'm not going to permit an interlocutory appeal. But then the Ninth Circuit unanimously reverses and says that, yes, as a matter of practicality, it was a final order. What was important is this, as I glean from the Ninth Circuit opinion. The bankruptcy judge had said, although denying the motion without prejudice, that the bankruptcy judge was going to try the case. There never would be a trial in state court. So as I read the Ninth Circuit, what they're saying is that you look at an order, functionally speaking. You don't look at the order in terms of being bound by whatever label the bankruptcy court puts on it. If you have a functional analysis, and that functional analysis tells you that the automatic stay is not ever going to be modified, then you have a final order. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well. Good day.